Avoiding bankruptcy. In this particular session, I want to talk about strategies for getting your debt back under control. Now, avoiding bankruptcy has 4 different steps, or 4 precisely, that I want to talk about. But the other aspects of getting your debt back under control and avoiding bankruptcy have to do with debts you may not owe, or certain debts that you think you owe, but actually legally you may not owe those debts. I'll talk about that in part 2. Also, the consequences of ignoring your debt. What could happen? What could go wrong if you actually don't pay them and just ignore them? And finally, are you even a candidate for bankruptcy? Now, there are certain tests that you have to take and apply to your circumstances. One of those is called a means test to determine, for example, if you're a candidate for Chapter 7. In other words, if you make too much money, you may not be able to apply for Chapter 7 relief. If your plan that you have is not feasible, meaning, given the money you have and given what you're able to pay, your plan overall doesn't make any sense mathematically, then you probably won't be able to apply for 13 either. So, and again, most people will be able to seek relief from one of those 2 provisions of the bankruptcy code, but you do need to make sure that you are seeking the right chapter of the code, whether that be a 7 or 13. And again, and that's going to be determined in large part by how you come out on the other side of the various tests that you will have to take in order to see if you're eligible. But again, I'll cover those aspects in the next video. Now, in terms of getting your debt back under control, there are 5 strategies to that. And the first one is assuming that none of your debts are in default, none of your loans have actually gone into default, meaning you still have the ability, you have a window of time, you have an opportunity to get in there and negotiate with your creditor. Then you have to think about reducing your monthly debt overall so that you can make certain payments that make sense. Strategy number 2 for avoiding bankruptcy. I mentioned this earlier, but negotiating with your creditors is crucial at every stage of the process. Remaining in communication with your creditors. I mentioned earlier about documenting everything. Sometimes you'll find yourself talking to people in a customer service desk. Many of the larger companies don't just have customer service centers in one state. They may be in several states. Sometimes you'll find yourself talking to someone in the Philippines or in India. And you may find yourself talking to a different customer service center every time you contact someone about your debt. And rarely will you talk to the person who actually has the power to assist you. But you have to be persistent in talking to creditors, and you need to document with whom you speak. So if you talk to a customer service rep, get their number, their name, and their location so you can document your efforts to stay on top of your debt. Because what you'll find is you'll spend an hour trying to get through to someone and finally talk to a customer service rep and possibly be disconnected. And of course, you think you might have gotten somewhere. They've escalated your call to talk to a manager. Next thing you know, you're talking to a manager possibly in a different state. You think things are resolved to a certain extent that day, only to return to the same issue tomorrow, contact the same number, and you're talking to someone entirely different. So it's important to document your efforts on the people with whom you speak. If you're able to obtain fax numbers, even though we're living in an email age, you want to do that so that you can fax documents summarizing or memorializing conversations and understandings that you've reached with, say, managers at a particular company. Generally, the people who answer the phone are not empowered to assist you. They're only empowered to escalate your call and to maybe document your concerns in a computer. I would also mention, most parenthetically, that if you're considering bankruptcy, do not mention that while you're talking to creditors. And the reason why you don't want to do that is because oftentimes you'll find things that you communicated to a customer service rep on a call intended to negotiate or to explain a circumstance. You'll find those conversations emerge in your credit report. So if you happen to say, well, if you don't work with me, I'm going to file bankruptcy, and you're not actually going to file bankruptcy, and again, until you've actually filed, you haven't, you might find that conversation in your credit report, customer says or indicates that they plan to file bankruptcy. Well, if it turns out you don't, then and you get yourself back together a couple of months later and you apply for credit, that comment could be in your credit report for 7 years. So you don't want to ever threaten anyone with bankruptcy. If you intend to file after you've done the proper analysis and you determine it's what you need to do in order to, get a fresh start or to get back on, to financial health, then you just do it. Don't ever threaten anyone with filing bankruptcy, because it's generally not helpful to do so. But it is helpful to communicate and be patient with creditors, because you have to remember, to that person who's answering the phone, you're just the person on the computer screen, or someone who has an account number. They don't know your personal circumstances, and they may not be empowered to help you, even if you spend hours explaining it to them. But you do need to be patient, but you certainly need to be persistent and document what your efforts are with regard to communicating with creditors. As I've indicated, many entities, many creditors, many large businesses now are offering all kinds of forbearance and all kinds of workout plans, and they will work with you to negotiate with you, because we're not talking about, an episodic situation, even on the scale of the mortgage crisis in 2008. We're talking about something that it impacted the entire planet. So, so the scope, is much greater, and the impact is magnified in degrees of magnitude. So no business wants to see customers in droves leaving or not returning because they didn't feel that they were being treated fairly. So companies, while they're not going to forgive everything, are doing what they can in many respects to try to work with people. So you need to take full advantage of that and talk to your creditors, about what's happening, and hopefully take advantage of things that they're offering voluntarily or sometimes involuntarily to assist consumers. The third thing in strategy number 2 in avoiding bankruptcy and preparing yourself for the process, if need be, is avoiding scammers. There are a lot of people who take advantage of consumers, and I suspect this COVID-19 era is not going to be an exception. I think there'll probably be people who will come out of the woodwork to take advantage of consumers who are looking for relief and who are looking for answers. Part of the reason I'm doing this video is to hopefully direct people in towards things that are credible and things that make sense, but most certainly away from things that don't, and that simply don't work. People who call themselves credit counselors or consumer debt relief specialists, many of these people are sovereign citizens. They're people who don't know anything about the law or personal finance, and you're going to get nothing but a lot of trouble, wrath, acrimony, wailing, and gnashing of teeth. I've had people contact me in the last couple of days saying, a company promised to make my debts go away, essentially, or to negotiate with my creditors. I paid them a bunch of money, and my creditors are still calling me as if nothing's happening, or no one's working on my behalf. What should I do? And the first thing I told that person to do was to contact the State Attorney General's Consumer Protection Division and report that company, because no one who tells you not to pay your debts should be believed or taken seriously. You can most certainly, as I've indicated, in some cases find yourself in a cage at the order of a judge because you're ignoring court orders or otherwise breaking the law and not paying your debt. So anyone who tells you not to pay your debt is someone you should avoid. Other people to avoid are payday lenders. Many people take advantage of payday lending. A lot of folks are struggling, and they tend to live paycheck to paycheck, and sometimes an unforeseeable event happens, someone gets sick, or a foreseeable event happens, their car breaks down, and they end up, needing a few bucks, so they go to the payday lender. Well, the problem with that, obviously, and most people who do it know it, but they can't seem to stop themselves, is that you end up paying, 400 sometimes % interest on money that belongs to you. So you certainly want to avoid payday lenders. You want to avoid anyone who's promising to renegotiate your public student loan, not a private student loan, a public student loan that I've discussed earlier, essentially money that's loaned to people who are pursuing higher education and is essentially governed or regulated by the U.S. government. Those loans have all type of mechanisms built in. You're not late until usually you've missed 9 months of payments, and there are all kinds of deferments and forbearance mechanisms built into those loans that will allow you to be able to weather a storm, a short financial shortfall, or even this pandemic if necessary. And you don't need any third party to intervene and do what you can do for yourself for free. So there are folks out there who will promise you the moon. Oh, I'll go in and renegotiate this and consolidate that. But the fact of the matter is there's nothing these folks can do for you at a cost that you can't do for yourself for absolutely free. So anyone who's promising to consolidate your loans for you for a cost, or negotiate a better rate for your student loan at a cost, any of these type of things needs to be avoided. Like no pun intended, the plague. So do not deal with any of those type of things. There are a lot of reverse mortgage scams that you want to avoid. A few minutes of internet research could probably save you a lot of wailing and gnashing of teeth. So there are a lot of different scams that are out there, but most of the people who are promising to do for you what you can do for yourself have neither the credentials nor the expertise nor the pure heart necessary to be able to help you deal with that particular crisis. Most of the things that these people promise to be able to do for you, trust me when I tell you, you can do yourself. You just have to be persistent, you have to document, and you have to be patient. Strategy 3 for avoiding bankruptcy: consumer credit counseling. Now, in strategy 2, I talk a little bit about scammers, people who promise to come in and help you renegotiate loans. In some cases, they promise that they will make these loans go away, or in some cases, they'll even tell you not to pay your loans. Don't worry about it, we'll take care of it. As I indicated, many of these people are, borderline or questionable sanity, and most certainly are ethically challenged. So you must avoid these people and not accept or listen to anyone who tells you don't have to pay your debts back. But consumer credit counseling, on the other hand, sometimes they're known as CCCS, is something that might be useful to you. And this is the third strategy for avoiding bankruptcy. You want to look into this. Now, my suggestion is that you only plan to patronize or seek information from consumer credit counseling agencies that are nonprofit, meaning they're not into this to get rich. Their goal and their primary aim is charitable, and they're trying to help people find actionable strategies, much like this video, to address financial challenge that you're having. So these companies can be useful, and sometimes they'll sit down with you, if not every time, sit down with you and really do a deep dive, looking at your finances, looking at what you can afford, and helping and assisting you in making recommendations for trimming some fat off of maybe your expenditures. They can help you, weather or navigate through the different tiers of debt. Telling you what debt you really need to make sure you make a priority and pay those first. Give you some strategies and ideas about stretching, dollars over a short period of time if you expect to be back on your feet fairly shortly. The other thing they can do in some cases is they can help you carve out a plan to pay back your creditors, much like a Chapter 13 would do. Now, Chapter 13 is Chapter 13 of the U.S. Bankruptcy Code, and essentially it's a plan whereby you pay pennies on the dollar on the debt you owe over a period of time. Now, I say pennies of a dollar, not to necessarily minimize the fact that you're paying a lot of money every month under a Chapter 13 plan, but it's much less than you actually owe generally. Sometimes it's just pennies on the dollar for certain types of unsecured debt. But a reputable consumer credit counseling service, again, they're usually nonprofits, the ones that are best, are going to help you carve out something similar to a Chapter 13 without having to go through the Chapter 13 bankruptcy process. So they can help you work out plans with your creditors, to compromise on it, and sometimes with minimal impact or detrimental effect on your credit report. So this is strategy 3. If you've done strategies 1 and 2, and you're and either of those helped, or you want to use them in combination, you want to check out consumer credit counseling services. Now let's talk more about some of the common forms of bankruptcy. Essentially, for the purposes of this video series, I'm only talking about Chapters 7 and 13 of the Bankruptcy Code, but the Coronavirus Aid, Relief, and Economic Securities Act, which President Trump signed on March 27th of this year, made some substantial changes to the Bankruptcy Code. And again, that act is sometimes referred to as the CARES Act. It made some substantial changes to the Bankruptcy Code. The first thing it did is it amended Chapter 11 of the Bankruptcy Code in such a way that it streamlines the reorganization process. So Chapter 11, which I'm not covering, is really kind of, they call it debtor in possession bankruptcy. So if a business is going to, the business owner is going to remain in possession of the business through reorganization, of their debts, then that's a Chapter 11, which I'm not covering. But the CARES Act does amend Chapter 11, and it carved out some important pieces for people who are in Chapter 11 bankruptcy. So just wanted to mention that one. But in terms of consumer bankruptcies, Chapter 7 and Chapter 13s, again, small businesses can file Chapter 7s as well. But in terms of consumer bankruptcies, it did a couple of things that were important. Number one, I've heard people refer to them as stimulus checks. Any checks that were appropriated by Congress and disseminated to taxpayers as a form of relief to help them manage the stay-at-home orders and the impact of the virus, those particular payments are exempt from your bankruptcy estate. So you're not going to have to account for any payments you might receive as a result of the CARES Act if you end up having to file for Chapter 7 bankruptcy. It also excludes from disposable income any payments you might have received as a result of the CARES Act, and it permits Chapter 13 debtors. When you're in bankruptcy, they call you a debtor. It excludes Chapter 13 debtors from certain requirements that their bankruptcy be wound up in a certain amount of time. So if you were in bankruptcy, in a Chapter 13 bankruptcy during the pendency of COVID-19, you can extend your payments that would have ordinarily have to have ended, say, in 3 years to 7 years. So because the understanding is that if you're not able to work during the pandemic because of a shutdown or because your job is not considered essential and was therefore not there, then your payment plan could be extended several years, up to 7 years, to allow you to be able to comply with the installment aspects of your Chapter 13 plan. Strategy 4, Chapter 13 bankruptcy. So if you've explored strategies 1, 2, 3, and you find yourself still needing relief, Chapter 13 bankruptcy will be step 4 of the strategy, and you really have to explore whether or not it's best for you. Chapter 13 bankruptcy does, the first thing to know about it is that it imposes an automatic stay on all collection activity. So once you file your bankruptcy petition, any creditor who calls you at that point, being mindful of the fact that you are in bankruptcy, risk violating the automatic stay. And I've seen judges impose $10,000 fines for people violating the automatic stay. So if you file bankruptcy and you get a collection call, let's say 3 or 4 days later, and that creditor has received notice that you filed bankruptcy, you may find that creditor will hang up the phone the minute you say, I'm in bankruptcy, because they don't want to be found in violation of the automatic stay. It's serious business. But that's the most important thing. And the idea of that is that when you're in bankruptcy, you're under the protection of the court now, and the court is going to make sure that your debts and your assets are administered in the best interest of creditors and within the law of the bankruptcy code. So the automatic stay is the first thing to know about it, and that's it's really powerful, and it extends even after your discharge. So if you have a debt that was discharged in bankruptcy court years ago, and a creditor calls you years after you've emerged from bankruptcy court trying to collect it, they could stand in violation of the automatic stay and could suffer penalties if that was brought to the court's attention by a proper motion. Chapter 13 takes longer than a Chapter 7. It could take 3 to 5 years, and as I indicated earlier, under the CARES Act, it could be extended up to 7 years under certain circumstances. But 3 to 5 years to pay back your debts. Now, your debts have to be part of a Chapter 13 plan. The payback plan has to be feasible, and the debts in a Chapter 13 are broken into tiers. The top tier debts are debts that are secured by property. So, for example, if your home is, if you have a mortgage on your home, those type of things. If you still owe on your vehicle, those type of debts are at the top tier of the feasibility, payback plan, because in the event you don't pay back those debts, those properties, can be seized. So obviously you're going to probably end up paying those back close to, if not the exact amount of what you owe. Other debts that are not secured by collateral credit card debts, those are going to be on kind of the bottom tier, and those will be paid back pennies on the dollar. But the plan has to be approved, and every creditor that you owe will have the opportunity to object and say the plan is not feasible. They can have, they can create situations where you have to appear at depositions and answer questions, about your finances if someone has reason to suspect you're not disclosing everything, or if you paid back someone. Let's say you paid back your brother who you owe money to the detriment of creditors. So you pay this person back before you file, and someone finds out about it, you can get in a lot of trouble if you didn't report that. And of course, if you did pay certain people prior to filing, sometimes those monies that you pay will get clawed back by the bankruptcy trustee for the benefit of those creditors. So, but the bottom line is that there's a plan. It has to be feasible. There are tiers to who gets paid back first and at what percentage. You have to make sure that you make those payments on time, and that you're communicating through your counselor or whoever is assisting you with that to ensure that you're meeting all the requirements of the plan. And of course, oftentimes Chapter 13s are converted into Chapter 7s because during the pendency of your Chapter 13 plan, circumstances might change. God forbid somebody gets sick and you end up not being able to work, or something happens, and you may then find yourself qualifying for a Chapter 7. And should note that a lot of people file Chapter 13 because on the other side of that Chapter 13, your credit is in a little bit better shape than a Chapter 7, because in a 13, you've actually paid back your creditors as agreed. So your financial position and your credibility, your standing, as a person, as a consumer, is a lot stronger in a Chapter 13. So that's the reason why Strategy 4, not Strategy 5, because it's something you need to consider before you consider liquidating everything. Is there a way I can pay back my creditors, in a plan and a framework and a matrix that makes sense, as opposed to trying to quickly rush to, to jettison all my debt and liquidate everything, because many people are not able to file a Chapter 7 because of the fact they're working and they make too much money. And there's a means test for that, and I'll talk about that in Part 3. But many people are not able to file a Chapter 7, and they must file a Chapter 13 because they're a little bit better off than someone who's really in dire straits and, let's say, doesn't have a job at all. So Chapter 13 has some benefits. There's some restrictions on it, and you really do have to be rigorous in terms of making your payments in a timely fashion, or less you serve. You stand to possibly be discharged involuntarily from the Chapter 13 in the bankruptcy court because you're not complying with the strictures of the plan. So it's very difficult for a lot of people, and as I indicated, some people over a period of time, the situation worsens and they end up having to convert that 13 to a 7. But if you can follow the strictures of it and follow the plan, you're going to be a lot better off than you were had you filed a 7 in the eyes of creditors, in the eyes of anyone that looks at your credit report. And again, with a 7, you're looking at 10 years potentially having that mark on your credit report, whereas with a 13, you'll probably only have on your report 7 years because you've already spent 3 in bankruptcy court in a Chapter 13. So that's important to know. Now, the last thing about 13 I want to mention is that, as I've indicated before, certain tax debts, child support, certain type of agreements to pay spousal support, any type of criminal conviction that carries with it a fine or restitution, those are not dischargeable in bankruptcy court. Neither are student loans, except for extreme hardships. So there are certain things that you'd have to know about your circumstances before you actually file to make sure that it is the right fit for you. Now, Strategy 5 is Chapter 7 bankruptcy. Again, if you don't qualify for a Chapter 7, it'll be because you make too much money. And that's something that the U.S. government has carved out and labeled the means test. And the means test looks at the average, or the average income per state, and it's a separate category for people in the U.S. military. But if you're not in the U.S. military, they're looking at your income per state. So the income you need to qualify, say in Alabama, is not the same income that you would need to have to qualify, say in Silicon Valley, or in California or in Washington State somewhere. So in other words, the mean income in Alabama is lower than, say, it would be in Silicon Valley. So as a result of that, the income that's considered average or the mean for people in that particular state is going to be lower. Therefore, the threshold required to file Chapter 7 in Alabama is different than it is in California. So all the states vary. Very few have the exact same amount. Some are very close, but typically, if you are not able to fall within that threshold for your state, you're not eligible for Chapter 7 unless there are certain exceptions that are employed to take into account your special circumstances that might then allow you to qualify. And I'll talk about that more in part 3 of this series. But for the purposes of this discussion and strategy 5 of avoiding bankruptcy and getting your financial affairs in order to address and prepare yourself and survive the pandemic era, Chapter 7, you have to know that there's a means test you have to take in order to qualify. But the good news is that if you go under Chapter 7, you meet the means test either through kind of a prima facie, they kind of call it a prima facie test, meaning you just kind of take your income, the number of people in the household, and you fall below the threshold that's set by the U.S. government using aggregate statistics per state, then you can file and you'll emerge from that bankruptcy more likely than not owing anybody anything. So you get a complete fresh start. All your debts are liquidated. The automatic stay that I mentioned in strategy 4 applies to both, really all forms of bankruptcy. So creditors aren't able to harass or call you during that period of time or ever after if you receive a discharge of those particular debts. And most Chapter 7s are actually what they call no asset bankruptcies. People go into their Chapter 7, they're in dire straits. There might have been a health crisis, or in this situation, you might have been forced to stay home for 90 days or so and unable to work, or your job may not have been available because it was considered non-essential. So you didn't have income during that time, and you may have received some money pursuant to the CARES Act, but it wasn't sufficient to cover your expenses. And as a result of that, you find yourself in the unfortunate position of having to seek relief from the bankruptcy code. Well, in those circumstances, chances are you're going to come out of the other side of that Chapter 7 in roughly 2 months, sometimes 6 months, depending on how clogged the docket is at the bankruptcy court, or how complicated your bankruptcy is, or how many people, if any, file objections and try to challenge some aspect of your schedule that you have to file in a Chapter 7. But nevertheless, on the other side of it, you don't owe anything. Now, an asset bankruptcy, as opposed to a no asset bankruptcy, is when you actually have high value assets. You were doing really well prior to the pandemic. Let's say you had a couple of Rolex watches. On the other side of that bankruptcy, you're not going to have those Rolex watches anymore. Those Rolex watches are going to be essentially taken and sold for the benefit of your creditors. But for most people, they just have normal household goods. They have, their furniture, they have, dining room, living room set, bedroom sets for the kids, microwaves, that kind of thing. Maybe they have a car, maybe they don't. But chances are you're going to come out of that not owing anybody anything. You'll probably keep everything that you had going into it because there is a state exemption or federal exemption that accounts for that asset, and including your retirement accounts are exempt, for example. And again, you can keep a certain dollar amount of cash on hand. Your children's 529 plans, for example, are exempt. But again, I'll talk about that more in part 3.